My name is Tanya Thompson. I am an attorney here for the school district, and I do a lot of student issues. I do mostly special ed issues, discipline issues, and 504 as well. So that is my area of specialty. I also do a little bit on the employment side, but we have Bob Cohen, who is our general counsel, and he does most of the adult stuff, which would then be the employment, labor and employment issues. So I, again, appreciate your being here at the end of your summer break. I want to take the time to introduce the guests that we have here with us. Today there are 4 attorneys here that have availed their time to provide you this training. So I want to let you know who we have with us. First of all, John Stanek is an attorney. He's in private practice with Anderson Dude Lebel. And just to give you a little bit about his background, he's got a very lengthy background in school law, serving as internal counsel for Douglas County as well as Cherry Creek. He was also an executive director for student achievement, special education there in Cherry Creek, as well as an associate in-house counsel, as previously mentioned, for Douglas County Schools. A regional director for special education in Douglas County, and he started his career initially as a school psychologist. So, very interesting pathway to law, and so I have very high regard for John and his years of experience. And so after many years in education, he retired and went into private practice, and now helps school districts like Academy District 20 when we have some more complex issues, or we just need a thought partner at working through some of the issues that come our way. So thank you, John, for being here. Did I miss any details that I should mention? All right. He's got a great newly built cabin in Woodland Hills. So if you need some small talk, just ask him about that. And the pictures are amazing. Next, we have 2 attorneys from Disability Law Colorado, and their area of specialty, as you might have already presumed, is disability law. Ms. Jennifer Levin is here with us and joined Disability Law Colorado in 2009 as an Equal Justice Works Fellow. She then became a full-time employee working on individual rights, client assistance, beneficiaries of Social Security, and special education programs. In 2014, she became the coordinator for the VOTE program, and in 2015, the leader of the education team, which focuses on rights of students in preschool through grade 12. In addition to representing individuals with disability rights claims, she presents trainings on voting rights for people with disabilities, special education, and rules governing restraint of school children with disabilities. So we're very proud to have you here, Jennifer. Thank you. And Miss Emily Harvey, also from Disability Law Colorado, has worked in the prosthetics department at Walter Reed National Military Medical Center, intending to become a prosthetist. Prosthetist. Thank you.
I can come up with some good jokes for that one.
Okay. My phonetics are failing me. I apologize. This was a career that was familiar to her because she had worn a prosthetic leg since the age of 2. But along the way, she decided to pursue law instead. She attended George Mason University, where she was a research editor on civil rights, on the Civil Rights Law Journal, which fueled her passion for disability rights. She is the staff attorney with Disability Law Colorado and is a team leader of the intake team. She's also the co-founder and president of LIM 359. Is that right?
Yes.
Okay. And that is a nonprofit that provides activities-based support system for people with limb loss and limb difference. She is board co-chair of the Cycle of Hope, a nonprofit that provides opportunities for women who use wheelchairs, and an ambassador for skirt sports. In her spare time, she enjoys training for triathlons, reading, and spending time with her husband and friends. However, she declined the invite to do the incline after our meeting today.
Well, I just did a triathlon on Sunday, so I'm recovering.
Life is busy, right? All right. So I appreciate the ability to introduce our people. Thank you so much, Ms. Harvey, for being here today. And as we get started and transition into our time together, we have 2 hours. That's a lot of time to be sitting. I want to invite you to ask questions as we go along, but because of the amount of information that we have, we may have to ask to put your question into the parking lot to get to as time permits. But at the onset, there's something that brings each of us here today, some questions, some wonders about 504. What questions do you have even before we get started? You're going to write? Really? Our training has been that thorough and fantastic in the past? Oh, okay. All right. Meeting adjourned. No. Unfortunately, no. We really do need to seize this opportunity for training and learning. And so if there's any questions that you come up with along the way, I want you to ask them. And please don't be offended if we say, we'll get to that, or let's put that in the parking lot and come back to that at the end.
Can I press that a little bit?
Sure.
My bet is that there are people in here who know Section 504 somewhat at least, right? That you are familiar with it, maybe even quite familiar with it. And then there are others of you that may not be, right? So you can kind of do a general raise of the hands, like who would be very proficient, who would kind of rate themselves as very knowledgeable, who might be kind of a beginner, and who's somewhere in between, right? Each of you have different questions. So what we would like to do is to make sure and shape some of our work and the presentation to make sure your questions are answered, because some of the presentation may not address your questions. So I'm going to press a little bit, and it's usually a scenario. Like, this happened to me, what would you do if, right? Or what do I do when, right? So I'm going to press that a little bit. I see kind of there's a little bit, that's a good question. Whichever one's kind of doing that, right? It's a good question. Did I see a hand? Come on. Don't be shy. Yes, ma'am. Thank you.
So I think my question is kind of like a scenario.
Okay.
So when you're in that 504 meeting with parents,
Uh-huh.
and they request a specific accommodation.
Right.
But we say, well, as the school, we kind of have to look at that a little bit.
Okay.
To see if we could make it work. And I think my question is, what, like, legally are we allowed to say versus instead of just being like, nope, that's not going to work, sorry, because then we get those frustrated response back. So I think just the good, like, terminology to use when we're kind of getting in a contentious situation with parents because they want something, but we can't necessarily provide it in the way that they want it.
Okay. So let me see if I can tee that up as a real brief question, okay? Which is, when you're in a 504 meeting and you're deciding on accommodations, how do you decide what accommodations are appropriate versus what accommodations might not be appropriate, right? So what are appropriate accommodations, right? Is that, and there is usually kind of a give and a take in that, right? But that would be the way to say that, right? Is how do you sort out the accommodations? And behind that might even be, how many accommodations are enough accommodations, right? Because I've seen scenarios where there's like a laundry list of accommodations and it's like, put all these in there. It's like, well, wait a minute, some of these are applicable and some of these are not, right? So sorting out and making that decision around accommodations. Good, okay. Well, who else? And you know what? Presentations like this are like church. The sinners are in the back. That's right. That's right. Yes, ma'am.
I think to piggyback off of that is what can parents demand and what can they not demand?
Okay.
So parent rights versus the school rights.
All right. So I'm gonna sort that out a little bit. Like, how do you manage a demand? Like an accommodate, like again, it gets to.
Even to the point of I'm demanding a 504. And we're like,
Oh, okay.
Yeah, I don't think this really requires a 504.
Okay. So this, so then that's a different question.
So it's like demanding a 504, and then once they get the 504, what accommodations then can be
Right, and I bet there's some few English teachers in the room that know of a demand as a type of a request, right? Right? So you got to hear demand as a type of a request, perhaps a strong request. But so when someone requests a 504, what do you do? Would that be accurate? Or demands a 504, what do you do, right? And I'm assuming that they're not yet.
There's a major difference with some parents of request versus demand.
Correct. But it's all in this big bucket we call requests, right? So what do you do with a request and or a demand for a 504? And you need to hear that as a 504 meeting, correct? Okay, so we'll make sure and we'll address that, okay? What else? Yes, ma'am.
Have later through the presentation, this conversation about or some tools that teams can use to discuss reasonable, proportionate accommodations as related to the student's disability.
Good.
Because they look different, and so we want to make sure a parent may request something, is it reasonable, proportionate?
Good.
And then what kind of data could we gather around?
Good.
You know, is this accommodation necessary for the student, or are they
Good.
perfectly well without it?
So that reasonable or proportionate, I don't know what you mean. I don't know what you mean by proportionate in that
Certain
context.
disabilities will impact students differently, though it may be the same diagnosis
Good.
per se, and so you kind of have to evaluate what's proportionate for how that disability is impacting that student specifically.
Very good. So you're sorting out, in that conversation, you're sorting out what accommodations are appropriate and what are inappropriate, or,
How to help support that conversation with parents to get them to understand why, we don't want to say, well, we're just not going to do it. That's not the spirit of what we're trying to do, to get parents to understand, well, maybe the student doesn't need it.
okay?
And finding that balance between, you don't want to enable them and offering appropriate amount of challenge, and that's tough for parents to understand.
Good,
sometimes.
yes. And so what I'm hearing in that is what is appropriate versus what is, I'm going to call it inappropriate, or one would say, what is an accommodation versus giving an advantage, right? I mean, usually it's something like that, right? Like, is this giving an advantage to somebody that other people don't have, right? That's always the watch out for. Okay, good.
I think sometimes as an educator, I maybe have a different perspective than the parent might, but I wonder if sometimes if our accommodations are actually a detriment to their kid, that they want something that's going to be long-term detrimental to their education because it's so advantageous to them that it doesn't require.
So again, that's coming in, I'm hearing kind of a group of questions, right? So we can keep those in that, and that is what is appropriate, what's in the discussion of accommodations, right? What is appropriate and what isn't, or what may be giving advantage, or in your question, a detrimental advantage, right? Okay. Other questions? Yes.
It's the same thing, because sometimes I ask myself the question, is this appropriate for a healthcare plan or a 504? Because a healthcare plan, we can still make some of the same accommodations that parents are requesting in a healthcare plan for certain health-related disabilities versus a 504 that is more legalistic, it follows the kid, and, and so I'm trying to decide
Okay.
So
Why
don't we?
that healthcare plan versus the 504.
You've asked a question I don't think you know you've asked, which is, what is the difference between and should a health care plan be incorporated into a 504 plan, right? That's what your real question is.
Or when do you do one versus the other?
Well, one versus the other, as well as how do they fit together, right? How do they fit or inform each other, right? Would be another question that's in there, right? You may not want to know my answer to that, by the way. But with that said, have we filled up the sheet yet? There's a limit to the sheet on questions. So it's as many questions, you can only ask 6. We're at 4, no. So let's see if we can wrap it in. We're going to be definitely addressing each of these. Yes.
I have a lot of questions around teacher accountability.
Okay.
And when to kind of agree to disagree on whether an accommodation should be in place.
Okay.
Versus parent, counselor, teacher, administrator. And then what it looks like when a teacher really advocates for, well, this is a sixth grader, and they should be more independent and we're enabling them.
Okay.
Or, kind of how to have some of those discussions and when administration needs to step in because 504s aren't being followed.
That's a different question. But so what I'm hearing again is that sorting out in the accommodations question. But then I'm hearing, okay, so we put a plan together. What's our obligation to implement it, right? And it's kind of like Howard Hughes. Is anyone in here old enough to know of Howard Hughes other than me, right? What did Howard Hughes know other than being this eccentric kind of creepy guy in a hotel or something, right? What else is he known for? Aviation. And what did he build? The Spruce Goose. And what was true about the Spruce Goose? It was a huge, elaborate plane that couldn't fly. Couldn't fly it. Would not fly in the air. You don't want to build a 504 plan that won't fly, right? So with that said, we'll get into that. Like, how important is it to implement the 504 plan, right?
And what do you do when it's not?
And what do you do when it's not being implemented? Very good question. Any administrators in the room? That's right. That's right. It becomes yeah, there you go. You already hear the little cadence in that answer, right? Okay, good. So we've addressed the questions and we'll go forward.
Yeah. So this is our agenda. I'm not going to belabor this at all, but I would like to now turn it over to our team here today to get us started, to really transition us into the substantive issues that we're going to talk about here today.
Thank you. Happy to be here this morning. It's cooler here this morning than in Denver. So Jennifer and I got out of the car and we're like, oh, this is nice. Still not climbing the incline today. No, I can click. Yeah, thanks. So we're going to start out today, before we get to the legal part of it, even though we're lawyers. One of the things that we at Disability Law Colorado really feel is important is understanding disability etiquette. Which is not a legal standard, but something that the disability community takes very seriously. So anyone who interacts with people with disabilities, who here interacts with people with disabilities ever? Everybody does, okay? 25% of the population, 20 to 25% of the population in the US has a disability. So I guarantee you interact with someone with a disability. So the first kind of point that we wanted to talk about was not victimizing people with disabilities. They're not victims of their disability. That takes their power away to view it that way. So we don't want to do that. We don't want to assume someone sees their disability as a tragedy or something that they're suffering from. So people don't suffer from mental illness, they have mental illness. Sometimes people self-identify as suffering from something, and that is totally their prerogative to do that. But we, as third parties, should not put that upon them if they don't do it themselves. In my bio, you heard my leg was amputated when I was 2. Never have I seen it as a bad thing. Never have I believed I suffered from anything. It's always just been part of who I am. So if somebody, I actually had a man come up to me in the grocery store one time, and he just broke out in tears. And he was like, I am so sorry. It's just so good to see you out in public. And I'm like, I'm buying a loaf of bread. I mean, come on. Like, this is not a big thing. But he had put such deep, pressure on me to feel like I should feel inspirational for buying bread. And we just don't want to go down that road. Then on the other hand, we have people who maybe have been in a tragic accident. There are a lot of emotions tied to that. They've done a lot of things to work through that. Someone coming up to them 5 years later when they've already worked through all this and saying, I'm so sorry that happened to you. That's going to bring all those emotions back. If they're buying a loaf of bread, they don't want to do that in the grocery store with a stranger. So just better to not go down that road. It's important to make eye contact with people and don't avoid them. One of my least favorite things, and I can use my personal story because that's the one I know best, but one of my least favorite things is being in the grocery store. I don't know why all my stories in the grocery store. I actually don't shop at the grocery store anymore. I do instant thing, click list, and I go pick them up, but maybe that's why I don't go there anymore. So at the grocery store, a parent will have a child who is staring at my leg. and the parent's like, no, don't stare, don't look at it, don't, no. And I always make an effort to say hello to the child, and would you like to ask me questions about my robot leg? Because then we are opening that conversation, and we're not making it something that's taboo to talk about. When you're shushing the child, then that's making it taboo and something we shouldn't feel comfortable talking about. And we should feel comfortable talking about it. So you see somebody in the store, you want to ask them a question, make eye contact. If it's me, I'll probably ask you if you want to ask about my robot leg. And then I'll ask the child if they want to touch it, and then they hide behind their mom, and it's always fun. One of the other things is making sure that you don't assume somebody needs help. So if somebody in a wheelchair is going through a door, don't just assume they need help and they can't do that for themselves, although if you open the door for everybody, then it's probably cool. But we don't want to undermine their abilities, and some people with disabilities have worked really hard to train themselves to be able to adapt in this world so that they can be independent. So we never want to assume that they need that help. Don't underestimate the abilities of someone with a disability. Don't assume they can't do certain things because of their disability. I have seen a child who has one arm do a headstand and spin around on it. Like, kids can do amazing things, adults can do amazing things. Never assume that there's something they can't do just because of their disability. I can do the incline, by the way. I've done it a couple times. For the record. I also did an Ironman last year, so let's just get that out there. So, like I said before, many people with disabilities have worked really hard to adjust, and so, give them that space to show that they can do things before assuming there's something they can't do. This is a big one. Speak to the person, not to their caregiver or an interpreter or translator. If you have someone doing ASL, you still want to look at the person that you're talking to, not the ASL interpreter. They're not the person that you're talking to. If you approach the other person first, the person with the disability could likely assume that you view them as unequal or incapable of having that conversation, which it's possible that they could be incapable of having that conversation, but you should at least give them the opportunity to engage. And if they have significant developmental disabilities, you probably are going to end up having the conversation with the caregiver, but at least start from the point of equality with that person. Be cautious of using outdated offensive terms. The term handicapped is technically not acceptable anymore, even though we call it handicapped parking. The Fair Housing Act still says handicapped. Disabled or person with disability is more appropriate. Wheelchair bound is another one that I hear come up a lot, that people who use wheelchairs are very offended by. So that's a big one to stay away from, that we still hear and see in records a lot. And then I say, when in doubt, use people first language. Rather than saying a disabled person, say person with a disability. It puts the person first. That's the general standard it's actually changing, but that's the safe way to go about it if you're not sure what to do. It's very mixed among certain populations as to how they want to be referred to. The deaf community definitely wants to be called deaf, not a person who is deaf. The amputee community is very split as to whether they want to be an amputee or a person with limb loss and limb difference. I'm an amputee because my leg was amputated. I have a friend who was born without her arm and leg. So she says, I'm not an amputee because this is how I was born. They never amputated. And so that's not a term that is applicable to her. And so always try to, if you can, hear how that person talks about themselves and mirror that. So I can't tell you that there's always going to be the right way and the wrong way, but if you mirror what the person, how they're referring to themselves, that's going to be your best bet. But we had a woman who used to work in our office, and she had developmental disabilities, and she was a very big self-advocate, and she would always say, I'm Michelle. We label jars, not people. I'm Michelle. So always divert to the person as who they are, and that's your safest bet for interacting with them. And now that I made some jokes, I'm going to turn it back over to John, who will probably also make some jokes about the law, which is harder to do. So,
Thank you. You know, there's got to be a joke. What do you call 4 lawyers in the same room, right? I mean, there's got to be like maybe a light bulb waiting to be changed or something. I don't know. Let me ask this. From Emily's presentation, just in those few slides, several slides, have any of these questions been further clarified? An answer? No? Anyone? Like, what are the appropriate accommodations? Has that been clarified? Somewhat, maybe? I mean, I get that you're listening for a legal answer, but in terms of what you're there for, right? What you're in the meeting for, what you're designing a plan for, right? What are you listening for in that meeting? I get it that you're listening for a legal answer, right? But have any of these questions been maybe surfaced or clarified a little bit? What?
I would say with the, like the language, like if you're writing the 504, not calling, not using verbiage, appropriate language. And then using the people first language instead of their disability.
Okay. What else? Yes, ma'am.
We're not supposed to assume that they need help. We let them tell us what accommodations they need.
Very good. So you're listening for abilities and capabilities as well, and what is appropriate given their circumstances, right? And their abilities and inabilities, right? Okay. What else?
I think number 2, the how to manage a demand, because I think most of the time, it becomes school and parent, and we forget about the student. So if the student is able to articulate what they need and what will help them, I think this would be that.
Well, and also about if one wants to accomplish something, right? And it might be in a school day, there's a lot of things in a school day to be accomplished for youngsters, right? And maybe it's lunch, right? Or maybe it is opening a door, or right, accessing a bathroom, whatever it might be, right? There's a certain dignity that comes with that, but there's also the how can we make this work? You hear kind of a practical? There's a real practicality to this, right? Right, very good. Okay, so let's take a look at what the law says. Now this, under all this Section 504 stuff, the law itself is fairly brief. So just listen to this law. It says, no otherwise qualified person with a disability, individual with a disability, no otherwise qualified. What does, I'm going to hit the pause button right there. What does that mean? No otherwise qualified individual. There's certain qualifications to things, right? So no otherwise qualified individual. Like let's say it's baseball. Rockies, what's going on with the Rockies, right? Okay. Anyway, so it's baseball. What accommodation would be made for a baseball player? A person who's otherwise qualified to be a baseball player. Does that make sense? Right? So what are the qualifications for a youngster coming to school? Usually it's very simple. They have to be of a certain age and live in a certain proximity to the school or area, or have applied through a certain process, right? That makes them otherwise qualified. The caveat is you don't do that without the accommodations. You do that with the accommodations, right? So just notice that that's the language, okay? Shall, solely by reason of their disability. Solely by reason of their disability, be excluded from, participate in, or be denied the benefits of. Notice how broad that language is, very broad. The benefits of, participate in, be excluded from, or be subjected to discrimination under any program, very broad language, any program, or activity receiving federal funds. So let's just remember I just referenced lunch. What's so about lunch in public schools? Free and reduced lunch, receives federal funding. What else? It's a program of a school or a school district, right? Very large program, right? Pardon me? And the school receives federal funding, and the school district may give that to a charter school, right? Do you hear how broad this language is, right? And any program or activity. So what are some of the activities that schools engage in? Athletics. Music. Field trips. Up in the mountains, 6th grade, end of the year thing, right? Those are activities and those are programs. And if you kind of disaggregate a school day, you will see a lot of programs and a lot of activities, right? This just, if you kind of set with this language, many of these questions will be addressed if you think about it, right? What type of data to use, right? Well, what type of data to use? What information do you need to know about certain students? Are they of a certain age? Are they of a certain application? Have they completed the application process? Have they, right? All of that stuff are legitimate questions, right? Are they otherwise eligible? And what activity are we talking about? It gets to this. What are the appropriate accommodations? What is the program we're talking about? Sometimes I think people get all locked up in accommodations and they're not asking the question, well, what is the activity? If it's about accessing a bathroom, that's much different than, I don't know, going on a field trip to the zoo. It's just different. And so the accommodations may look different, right? If I'm going to a field trip and I have diabetes, right? What might be an appropriate accommodation if I'm going on a lengthy field trip? Having certain insulin plans available, having certain health care plan available, having certain people trained in sugar checks and so on, yes? Why? Because it's a lengthy field trip. And insulin is likely to run out during certain times of the day, during certain activities, right? Same with, do you hear that? So looking at the activities and managing that points to the appropriate accommodation. Do you see that? This is a logic game. It's a logic test. It is a connect the dots, right? How can we make this work, right? Very practical. So approach this very practically. Okay, so this is the law. It also has an interesting history behind it. If you think of Section 504, and later in the slides we bring in IDEA, special ed. And the reasoning is that 504 came before special ed. It's a Section 504 of the 1973 Rehabilitation Act. It's been around a long time, okay? And IDEA was written in 75. And you wonder why that sequence? Well, Senator Hubert Humphrey was very spearheading on this, on Section 504 of the Rehabilitation Act. And it prohibited discrimination of federal funds. And schools were discriminatory prior to Section 504 of the 1973 Rehabilitation Act. And they were prohibiting students without certain testing and with certain criteria, saying you can't come to school if you don't have an IQ above X, right? And so parents were left in a conundrum. What do I do with my child if they're not going to school, right? And there was staying at home or going to an institution was basically where it was left at, right? So 73 prevented that discrimination. And then schools had to go, uh-oh, What do we do? Right? And IDEA provides funding. IDEA provides some level of funding for schools to abide by the rules. So you hear how they fit together? And that's why I kind of inserted IDEA in here, because they do go hand in hand. And students with disabilities under IDEA are also protected from discrimination under 504. Do you hear that in there? So if I have a disability under IDEA and I'm on an IEP, I might need some accommodations for the field trip, depending on my disability. Do you hear that there? So that's how that all fits together, okay? So now, let's keep going here. Uh-oh. Which one here?
The arrow up top.
This is sometimes, I just need to clarify this, because sometimes this gets all buggy too, is that charter schools are somehow not public schools. No. They receive federal funding both from the school district and from other federal statutes and other funding sources, right? So just to clarify that charter schools are public schools much like your neighborhood school, right? They have a unique curriculum. They're designed under state law, basically, that allow for unique emphases that certain groups have applied for, and the authorizer authorizes them as a charter and so on. So the bottom line, though, is, for purposes of this presentation, charter schools fit in this same need for compliance with Section 504 and the programs that they sponsor. You following me on this? The activities that they engage in. They are not immune from the requirements of Section 504. If anything, they need to be very alert to, because the smaller, unique aspects of a charter school, if there are some charters that are, they're kind of an outward bound kind of a program. What am I thinking about? Expeditionary school, where they spend time in the outdoors, accessing all kinds of very difficult, demanding activities. As a charter school, or as a school that receives otherwise federal funding, they need to be paying close attention to this. Yes? For appropriate accommodations. Okay, here we go. So again, this is reiterating that all charter schools and their activities apply, 504 applies to those programs. And just to impress you a little bit, I put some legal citations. You got to add a few of those in there. So here we go. Because they receive federal financial assistance, it's obligated to provide under Section 504. So think of it this way. Sometimes I hear this question: how often do we have to have a 504 meeting? Come on, John, tell me once every 10 years or something, right? Tell me a legal answer so I can say John said this, right? But what makes sense? What makes sense if the 504 is really about accommodating and making it work for someone? What makes sense? When should the question, should I hold a 504 meeting? What should be ringing in your head?
At least annually, or if there's any big changes or transitions.
Why? At least annually, or if there are transitions or other activities.
Right.
Why?
Programs and activities can change.
Programs and activities can change. It's like, there is the preschool activity, the after-school preschool activity I got going. And John is on 504 plan. Does the preschool provider know what to do? Right? I need to hold a meeting to make sure that they know and that they're familiar with does it make sense? So keep your logic, keep your thinking cap on. That's the bad news about always looking for the right answer, is that sometimes we think John has the right answer versus I'm going to just think it through here, right? Okay, I saw a hand go up in the back. Yes.
Besides the changing activities over here,
Yeah.
I believe that the students can really change per
Very good. There may be a change in the disability. There maybe they're diabetic and now they're learning to manage their insulin quite well, right? Would that perhaps call for a change in their plan? Absolutely, because they are becoming much more self-sufficient. And you want to encourage that, and you want to have them be practicing those skills. So I'm a school nurse, and I'm saying, John's really becoming good at monitoring his insulin, so therefore I'm going to change the plan and make sure the teacher knows about it as well, but I'm going to change the plan a little bit, right? So just keep that thinking in place, because this is really about having it work for the kiddos, okay? So, great. So now we're going to keep moving on. And so just to scare you a little bit, okay? There's always a fear in these kinds of presentations. It's like that's why you don't sue, right? Here's a case. Just so you think I'm not making this up, this is the real deal, okay? Here is Virtual Community School of Ohio. It's a charter school. They resolved concerns. It's an OCR opinion. That case there means that this opinion came from the Office for Civil Rights, which is the federal department in charge of enforcing Section 504, okay? So the charter school resolved the concerns that it regularly neglected to evaluate students with disabilities before placing them on 504 plans. The charter school failed to evaluate a student with cerebral palsy who suddenly began using a wheelchair. Someone wasn't they were probably paying attention, like, oh, look, John's in a wheelchair now. Without going, you know what? John's in a wheelchair now. We need to check out what's going on, right? And make sure that he can access the science room or whatever, right? That something's happening here, okay? Also notice that one of these came out of Aurora Public Schools and a charter school. Here is another case. OCR in October of 2015, finding that a charter school may have violated Section 504 when it denied a student with a disability the opportunity to attend a school field trip with his peers. Let me back up a little bit. There's the question, it gets to the question of, well, kind of what happens if I don't, right? What happens what are the teacher's obligations? If you're have designed a plan is no good until it's implemented, right? There's like a life lesson in that. And so the whole purpose of a plan is to implement it, not to write the plan. The plan doesn't sit there dead. The plan is to be implemented by a person, right? And so what happens if it fails to do that is that the parents have the right to file a complaint with the Office for Civil Rights and claim that they are being discriminated against. And how are they being discriminated against? They are not being appropriately accommodated based on their disability. Does that make sense? So OCR receives, on a regular basis, receives complaints from parents of children with disabilities saying, this is happening here, and I think my child who is otherwise qualified should be accommodated differently, okay? Now let me back up a little bit. It gets to what's the difference between a health care plan and a 504 plan, okay? If a child needs a health care plan, one of the criticisms of a health care plan is, guess what is not told to them when that health care plan is developed? That they have a right, that they, have a medical impairment that substantially limits a major life activity, and that they have a right to complain about it to OCR. Those are called their procedural protections. So you'll see here in a moment that procedural protections are a key part of this. The right of a parent to complain and to file a complaint with OCR claiming that their child is otherwise qualified and they're not being accommodated. And they wouldn't know that except that the school tells them. And that's by policy and that's by right. So procedural protections are key to this. Okay. Here's another example, Colorado case, the Colorado Charter Institute. The charter school's effort to disenroll a child with a disability from its kindergarten program raised 504 and Title II compliance concerns. What do you think happened in this? Let your imagination run wild. What do you think happened? What was happening?
They couldn't make the accommodations that they wanted.
Somebody probably said that, right? Can't make the accommodations.
We can't meet your needs.
We can't meet your needs, right? You have to go somewhere else. The question is are they otherwise eligible? And that is with accommodations, not without the accommodations, right? So it's with the accommodations. Are they otherwise eligible? That's the key. And so this here is an example of watch out for, call it coaching people out.
John?
Yes.
Does that mean that our objective with the 504 is to provide accommodations such that the child would be eligible? Is that the objective, to say we're going to provide accommodations so that with those accommodations, they are eligible in all the ways that we had anticipated a child would be?
The short answer to that is maybe, right? It's a lawyer's answer.
Classic
The question
lawyer
was,
response.
the question was, is the purpose of the accommodations making a child eligible? Maybe. Let me back up and give you an example of something that I was involved in, okay? There was a pitcher on a baseball team. I'm not going to tell you what baseball team. And he was a pretty good pitcher, but he wasn't the best pitcher. And I don't know if those of you that know a lot about baseball, but I'm sure much more than I do, but there are incredible statistics maintained in baseball. I mean, pitches, number of pitches, types of pitches, strikes and balls and hitting averages and all kinds of statistics that are behind the scoreboard, not just on the scoreboard, right? And there were incredible statistics on this pitcher being maintained by the coach, right? This pitcher also had a visual impairment, and he had peripheral blindness in one of his eyes. And it was, I believe, his left eye. So when he was standing on the pitching mound, what was so about his peripheral blindness? He could not see first base. So guess what one of the statistics were? Stealing bases. Right? So he was still on the varsity team, but he was the lower pitcher. Parent filed an OCR complaint saying, you need to accommodate my child and he needs to be the first number one pitcher, right? And so we looked at it, looked at whether or not there was a disability, looked at whether or not the accommodation, and whether the accommodation could be made appropriately, right? Because what would be arguably an accommodation? When John's pitching, you can't steal. Or yeah, there's someone would clap if you're going to steal, right?
You have to clap before you.
And that was, and so what's happening arguably with that accommodation, if that were accommodation, I'm not saying that it was, but what would happen? The rules to the game changed, right? And so the OCR dismissed the complaint and so on and so forth. But you got to hear it as, are we changing the nature of the activity? Right? Is this all of a sudden becoming something other than baseball? Because baseball has stealing bases in it, right? And that's part of the analysis. Like, what's the nature of the activity? I've been involved in situations where there's rock climbing activities, very hazardous, and with a child with a profound disability. And it's like, wait a minute. I've had situations, OCR complaints, child with profound disabilities wants to be on the competitive swim team. And it's like, well, wait a minute. Can he swim? It's a key question. The nature of this activity is swimming, and we will not let him drown. All right? And so that's part of the analysis, the nature of the activities and the needs, and whether or not it's the term of art is fundamentally altering the nature of that activity.
John, can I share a fun fact?
Yes.
You're talking about baseball and the auditory cues, and they actually have developed now something called beep ball for people that are visually impaired, so that they have access to a similar sport to
Right.
baseball.
Right.
And they actually have a league in Denver, so it's
So
pretty, just a fun
you
fact.
can change the game. You can make a new game. But it's not, you hear that? It's not competitive baseball. It was competitive swimming, not recreational swimming. Right? So getting into that question of, well, what's the nature of this activity is a good question for that 504 team to be looking into, as well as teachers, to understand the nature of their activities.
And-
Now, the watch out for is you don't want to shape the activity to eliminate people. Like, I don't want John on my team, so I'm going to make it, I'm going to make him stand on his head when no one else has to stand on their head. Okay?
And I think that's where the otherwise qualified part comes in, because I swim faster than my husband with one leg. And
There
if
you
we
go.
were competing for a spot on a swim team, I would probably beat him.
There you go.
So I would be considered otherwise qualified, even with one leg, so long as I could stand on the blocks and jump in like everybody else.
Bingo. Right? So that's why you want to be looking at their abilities and the nature of the activity and their disability and accommodating appropriately. Let me kind of go down this path a little bit. Oh, I got to keep going. This is the bad news about putting slides in. If I don't finish my slides, I get complaints.
We're just shy of our halfway mark, too.
And it's like, John didn't make it through his slides.
Presentation,
Here we go. Actually, this lends itself to that question. Generally, while such criteria need not be waived to enable a child with a disability to participate, the student with a disability would be entitled to receive any reasonable accommodations or modifications to meet those eligibility criteria if necessary by virtue of their disability, right? So certain accommodations can be made, other ones can't. I literally, in the scenario I'm speaking about, had to speak very bluntly to the OCR investigator. The OCR investigator was, asking, well, why aren't you allowing this child to swim in the team? And I said, we're not going to let him drown. Can't swim. Not to say that others can't. He can't swim. And this is competitive. This is a competitive game. Okay? Now, applying criteria similarly after the provision of special education schools. Charter schools cannot deny admission to students on the basis of disability, stating that a district must ensure that its charter schools do not screen applicants for admission or who have disabilities or conditions caused by their disabilities. So how do you manage this? We pay great attention to process, right? Because it isn't to say the charter school is all to everybody, because no school is all to everybody. It's the appropriate accommodations. Applying criteria, again, similarly, after the provision, here's a case out of the Ninth Circuit. Just to, the difference between an OCR opinion and the Ninth Circuit or any circuit opinion is that one is by the opinion of OCR and one is by a circuit court judge, which is, or a panel of judges one step below the Supreme Court. So a lot of attention is paid to circuit court opinions, okay? Here's an out of the Ninth Circuit, finding that because a charter school showed all of its second graders for the school year lived within its attendance boundaries, the parent of a non-resident child could not prove that the school denied their son admission. So here's the criteria being applied again. You have to live in this area to apply here. You don't live in this area, you've appropriately been accommodated, you don't get in the gate. Why? Because you don't live here. Just like we would deny other people who don't live here. The watch out for is, do you have this slippery criteria? Is this slippery or is this hard, a hard line? So that would be an example, again, of appropriately using criteria to say, you're not allowed here. You're not on the pitching team because you have a higher stealing rate. Right? All right? That's the way it works. Counseling out is prohibited. It's discriminatory for a charter school, and you got to hear charter school in this. It's true of school districts too. I mean, it's just the federal funding piece. To encourage a student with a disability not to enroll in the school or to transfer out of the school because the student has a disability. Here's the frequently asked questions, again, published by OCR.
And I'll add
Yes.
that from a parents' advocacy organization, that's probably the largest complaint or the most complaints we get is being discouraged to apply or told to disenroll because they don't accommodate certain types of disabilities, which we would definitely go to, file a complaint or work with the school district over an issue like that because from our perspective, it's a process that should be addressed before denying or encouraging disenrollment. So we want to make sure that they go through that process and that it's definitely a meaningful process, not just, a date stamp, we did this, you're gone kind of thing. So that is the largest, I would say, number of complaints that we get.
So we'll be getting to the process here momentarily, but the key is that thoughtful process. Not a fake process, but a thoughtful process. Okay?
I have a quick question.
Yes.
To go back to the Levin or not Levin with boundaries.
Uh-huh.
I've worked with Tanya a lot on this in
Okay.
terms of, because of the choice law. And she's been really good about helping us understand that. But then especially with IDA or special ed, but 504s, does that,
So what we rely on to deny admissions based on school of residency is completely separate. That's the Colorado choice law. It has absolutely nothing to do with whether or not they have an IEP or a 504. It's easy to conflate them into one, and so dealing with it as a separate issue is really the starting point when we weigh under what rationale would we deny a student enrollment, and if it's because of their non-resident status. The hard part is though under choice law it says that the district of resident is responsible for the costs of providing services, and so that's where we tend to conflate when we look at what services a child needs in order to provide that accommodation. We have 15 districts here in El Paso County. Amongst the superintendents, they've agreed that rather than you, District 20, deciding what our district, our resident student needs and then billing us, because, again, we're responsible for those costs, you just send them back. We'll evaluate, we'll determine how we want to provide those services because we have the burden of bearing those costs.
and that applies to 504 too then?
Any child with a disability, correct. Yeah.
Okay, that's clear.
A charter school erred when it failed to evaluate the student after the father provided medical documentation. So this gets into the when. This is the demand. How to manage a demand. You got to hear this as a request. And if someone is claiming, I have a disability, you don't know. Consider yourself on notice. You don't know what disability or its nature, so what should you do? Hold a meeting. There's like a sign for that, right? If you keep misbehaving, I'm going to invite you to a meeting, right? But it is. It's like that's what you want to be thinking. Like, okay, well, we'll consider your child's disability. And what is it, right? Now, there's this part. Sometimes the student comes in with medical documentation, and sometimes they don't. So now what's your obligation? I have ADHD, but I don't have a diagnosis or something like that, right? Right? So what are you to do? Who in your world, that's why I do the hand in glove with special ed, who in your world has a lot of knowledge about evaluations? Special ed. So consider a special education evaluation. Why? Because there would be a medical person there, a nurse. There would be a psychologist there if they're talking about depression or anxiety. There would be a person there evaluating their academic assessment and so on. And a special education evaluation can fit in the responsibility of a Section 504 evaluation, right? You see the parallels between the two laws, both in temporality, like in time, but also in process. And so don't be afraid. And what school districts get in trouble in is they go, well, if you don't have a documentation, you know, you're out of luck. And the short version is, well, you have a duty to evaluate. The team does. And it might be the special education team and or the 504 team. But the key in 504 is that it's a process. The key in special education is that it's both a process and the evaluation tools, right? I'm personally most nervous about statements such as, my child is so anxious they can't come to school. My child has a disability, but so I have to keep him at home. It's like, wow, okay, we need to evaluate. Do you hear that in there? They can be very nice about it, or they can be a jerk about it. You got to hear it as a request. That puts in play what's called the child find duty. It is the duty. It is an active duty on the district, not on anyone else. It's on the district to seek and find. It's a child find. It's people with disabilities. It's not like knocking on doors going, all right, who's in your house, right? It's not like that, but it does take place in newspapers, other publications, other public announcements, that if you are suspecting a child with a disability, seek your local public education agency, right? That is an active duty, and people get in trouble by thinking it's a passive duty that relies on the parent. Go ahead.
What you're saying is if somebody, we see that there's a disability, we're seeing, okay, the parents may or may not be requesting a 504.
Correct.
But we don't have medical documentation.
Correct.
It's onerous on us.
Yes.
To do the evaluation.
Yes.
Go through the MTS.
Let me even-
Process, but the 504 won't be in place until we've been able to do.
Correct. Let me even press that further. Guess who has the duty to do a medical evaluation if they suspect a medical disability? The special education team. You didn't know that, did you? It's been there a long, long time. It's nothing new.
And they have to,
Perhaps that's why I said don't forget about special ed. That if it's responsible for FAPE, so let me back up a little bit. Let's say that someone is saying, my child has such a medical condition that they can only be at home, and you need to provide education at home for them. Right? Home is a possible placement under special education, possible placement under IDEA. So what should you do? Is the special education director in here? Here we go. What should you do? Initiate evaluation, including consider a medical evaluation. Now, caveat, doctors are not very well informed on IDEA, in my experience, so you have to explain this to them. But if there's a medical condition that warrants this, it is in the IDEA that says you need to seek permission from the parent and gain the evaluation. It's the same thing as a reading disability, right? So you're not out of the forest by someone saying, I don't have a diagnosis. You can initiate the evaluation and find them not eligible. Now, that doesn't mean that they can take that to their physician and seek a prescription. It's a different purpose. It's for accessing education, yes? But that evaluation process is very, very important. And that's why you want to be kind of hand in glove with your special education department. Okay? So,
a little more to the anxiety component.
oh yeah.
That's a great one to start, because that does
Yeah.
happen.
Oh yeah.
And you say,
It used to be called worry, by the way. I'm worried about my science test now as I'm too anxious to go to school. But anyway, go ahead. Sorry. Take that out of there.
What's the evaluation process? So someone comes, they say, I'm worried, I'm too worried to come to school, or I'm
Yeah.
anxious about coming to school. School, usually we have our school counselors meet with the child. We have them meet with the family together. We kind of go through a process discussing it. Let's say it keeps going. What would be the next level of evaluation we could do?
Great. You got to hear, being in this game a long, long time, you get trained. It's like, I guess, maybe like musical notes. You start hearing, oh, that's a C, or, whatever, right? Those are musicians in the room, right? Special education directors and special education lawyers start hearing, that's a child find duty, right? That, oh, we need to do an evaluation. Oh, we need to, right? So when you hear anxiety, or you hear terminology that can be framed as a disability, do you hear that? Right? It's not that I'm doing drugs and eating Cheetos and watching creepy cartoons. I'm not doing that. I'm anxious, right? That sounds like it could be categorized as what? A disability. Like anxiety is one of the indicators of anxiety and depression in an emotional disability, right? So to watch out for is, do we need to do a special education evaluation and or 504 evaluation? But do you hear how the special ed would dig into that much more thoroughly? And determine whether or not there's a disability. Your suspicion is just a suspicion. So is the parents. You can't say, well, there isn't a disability. That's called the thumbnail evaluation, which is you're not in, you're in, right? Whatever. That's not an evaluation. The evaluation is a comprehensive process, right? And notifying the parent, we suspect you're telling us you suspect a disability. They can deny that. They can say, no, I deny this evaluation. And you can say, well, we suspect it, or you suspect it, but we're going to deny an evaluation. And there's all the prior written notice that needs to be done there, okay? But you have to watch out for that, because it seems to me as if that's, in our law firm, there's another attorney I work with who deals a lot with truancy. And man, in truancy court, you start hearing these stories, and it's like, okay, we need to talk to the district about possibly a special education evaluation here, right? Because they could argue that they're not receiving a free appropriate public education, and the district has denied them an evaluation. So you have to watch out for that, okay? So I would say the next step is to be contacting someone saying, do you suspect a disability? And if the answer to that is yes, let's do an evaluation. Okay?
The person who would conduct that evaluation, or the body that would conduct that, should start with the special education.
Perhaps. It depends on the nature of the disability, right? It's like, if it is diabetes, it might be something different than if it's like, well, they're not, they just can't read, so now they've just checked out of school. It's like, well, that sounds like a learning disability we need to dig into. Or usually the term I'm hearing more and more is anxiety. Okay? That's right.
We already were like, okay, so we only have X amount of hours for a school psych.
Right.
And how in the world, when we have, you get a lot of, that you see truancy. I work with Cindy Dude on truancy stuff, and I'm like, this kid has missed like 20 days of school, and we know but the mom's saying it's anxiety, and they can't do this. So then you have X amount of more hours that you need a school psych to be able to evaluate all these kids.
Yep.
who-
Do you see, I'm going to be somewhat sarcastic here. In these cases, do you hear, but they only had a sliver of a school psychologist, so never mind. No, you don't. You don't hear that. Or they only had a special education team that, for 4 hours a week. Or blah, blah, blah. You,
We work with you guys.
this is becoming the legal answer, right? You follow the child find duty, right? You go through the process. You evaluate. And yes, remember I started out as a school psychologist. I've given so many IQ tests you don't want to know, right? And you got to do what you got to do. It becomes, that's the job. That's the child find duty, right? And then you can sort out what the accommodations are and eligibility is within that process.
So as a special person, I just want to clarify, just because they have anxiety or they're stating that does not mean that they're going to be qualified.
Correct. Correct. They may not need specialized instruction. They may need accommodations. They may not need accommodations, right? We don't know. The key there is you don't know without going through that process. It is special ed and 504 is a procedurally laden set of laws. So you want to follow the process with fidelity, right? There's other parts that are substantive, but the key there is process. 45 minutes. See, okay. So here is this. I put this in here because some people confuse RTI. Put RTI as healthcare plans. Notice that there's no legal notice. I should put healthcare plans in there. There's no legal notice. There's no procedural protections. There's no child find duty. There's no comprehensive. And notice IDEA in Section 504. So why are healthcare plans now deemed to be insufficient under 504? Because none of this is over there. And so you need to be having the legal notice. You have the right to complain if your child has diabetes and they say you can't go up into the mountain trip. We don't have a nurse. It's like, huh?
Healthcare plans would be like / healthcare plans would be with 504.
No.
They're with RTI?
They're with RTI. You need to fold them into the 504 process. That is a directive from OCR that says, think about it in this way. Your healthcare plans, a child has an allergy, food allergy, okay? You design a healthcare plan, very appropriate. By the way, I am a fan. Remember, I was from Cherry Creek, right? And we had many nurses in Cherry Creek, and a large room like this full of nurses, wonderful people. They were about ready to attack me when I said, "You're telling me that the healthcare plans need to go through the 504 process," and I said, "Yes," and then I ducked under the table, right? And because of the procedural protections, notice, procedural protections, and so on. Okay? And that's the key, is that there's a legal binding element to this where the parents may say, well, I want my child to go on this field trip, and you're not setting up a plan?
Well, and the nurses are held liable by their license.
Correct. And nurses shouldn't be doing this by themselves. There's a problem with that, right? Because again, it's a team. So here's a little bit more about RTI, 504 and IDEA. Read it fast. I got to keep moving along here. Think of it in this way. The referral to a 504 or IDEA, no more than you would do this for a blind person or a person with a prosthetic device, okay? You wouldn't say, well, let's try an RTI for a while and see if you can, get through that door. All right? It's like, what? It's like, no. You need to apply appropriate accommodations in accordance to the child's disability, right? And you would no more delay or deny that because of an RTI issue. You do that the same way with other suspected disabilities. So you cannot delay or deny the child find duty on account of, well, let's try some other things. Trying other things are great. Good teachers do that all the time. And it doesn't replace the procedural protections. It's an active, it's not a passive duty. It's the duty on you. It's not the duty you can give others. And again, choose either or, but choose the evaluation process. The 504 tends to have things that are already in existence. Work samples, it used to be CSAP, what is it called now? CMAS scores, doctor's notes, other things like that may be very informative and sufficient to provide appropriate accommodations, right? IDEA would dig into much more comprehensive evaluation, but you want to be using those for your benefit, for your purposes, right, to give you the needed information to make the appropriate accommodations. It is the district's duty to evaluate. It's not the parent's duty to go out and get an evaluation. That is on you, right? And they refer when a disability is suspected. Well, one way it happens is even if you call it a demand, it's a request, right? And that's the way it happens. And use, for purposes of 504, use mostly already existing data. It may come from physicians. It's very appropriate to seek permission to speak with the physician and inform them what kind of accommodations work here, right? And that's very appropriate. And should a healthcare plan fit or inform a 504? Boy, they go together. And in fact, the rule from OCR is that healthcare plans do not replace the need for a 504. The 504 needs to be in place. Now, this is the truth that I've seen about healthcare plans. Nurses do a great job on them, and they're more informative than many 504 plans that I've seen. And so that information in a 504 plan, it doesn't take, or excuse me, the information in a healthcare plan doesn't, can be incorporated in a 504, or sometimes I've just seen it stapled. Because it's like, this is what you need to know about this child's medical condition, and I am not going to write it all into two separate documents. I'm going to attach them.
So is that to say that you put a kid on a 504 if they're on a healthcare plan?
Yeah, that's what I'm saying.
So the healthcare plan isn't a standalone?
Correct. And OCR has clarified that over the past number of years, just fairly recently. And the rationale is the rights. That chart that I put together there, that chart explains it because it is a legal process and a healthcare plan isn't.
John?
But the IEP is a standalone, could take place with the 504, correct?
It could. It depends on the disability, but it could. I mean, again, think of it as I may need some accommodations if I'm going on a field trip because my IEP doesn't cover it, right? So I need some planning around that.
John, it's not uncommon for us to have parents deny consent to evaluate or say, thank you so much for looking out, but I don't see my child as needing a label at this time. And so could you just expand on parental rights?
That's
in
the
that
awkward part
regard?
of this is that I've had it, again, in Cherry Creek, I had nurses saying, I've had parents call me and say, my child isn't disability, just leave them on a healthcare plan. What's the big deal here? All I can say is talk to OCR because they're the ones that are going to investigate us if we fail to do this. And we're not mislabeling your child. We're giving you additional protections. Please understand, right? Because for the most part, in 504, when you're talking about a food allergy, and it gets scary. All of a sudden, it was between you and the nurse, and now there's a bunch of people in this room. What's going on? And my child just is allergic to nuts, and what's the deal, right? And that I would say that's part of that etiquette. That it's like, I mean, can you say, yeah, OCR is making me do it? John says I have to do this, right? You can blame me. Whatever, but you want to be approaching it. Obviously, there are people who care about their child and the care that their child is appropriately accommodated for purposes of lunch. I mean, let's make it real simple. Kids want to have Jell-O too, right? And so what can we do to make this work, make the lunch program work for this kiddo? And that is very appropriate. So appropriately approaching the parents on this is one of the bugaboos, that's a legal term, that I've run into in this.
Still deny, because we had a grandmother who sweared up and down that their child did not have a hearing loss, and it got, it's like, no, there's a hearing loss.
Let me further clarify. Parents can deny a 504 plan. They can flat out deny it. And they can deny special education, they can unilaterally revoke special education, they can unilaterally revoke a 504 plan. I don't recommend that. We're trying to make it work, right? If they do, you provide them their procedural protections and you note that they are revoking it. Let me give you a case.
Can
Let
I
me give
add
you a
to
case.
that?
Yeah.
You provide them their procedural protections, but you let them know that the offer stands at any
Right.
time, that that 504 plan is available anytime that they agree that their child would benefit from those accommodations.
There's a case, I thought I had it in the slides, but I may have taken it out. I was up to like 150, 200 slides. But there's a case called the Kimball versus Douglas County Schools, and it happened after I left Douglas County, went to Cherry Creek. But it's a very informative case, and the parent was very unhappy. The child was on an IEP, and the parents were very unhappy with the IEP, and so they unilaterally revoked their special education, which they can do. So they unilaterally revoked, and then they demanded a 504 plan. So the district rightfully said, well, let's hold a 504 meeting. And they were in the 504 meeting, and guess what they handed over as the plan? They discussed the child's needs, they discussed, they went through the process of a 504, very thorough process, and guess what they determined was the appropriate 504 plan? The IEP. Because the child needed specialized instruction. This is a profoundly disabled youngster. Needed it. And the parent then rejected that 504 plan. They went all the way to district court, U.S. District Court. They sued. District Court agreed with the district saying, you offered a IEP, parent unilaterally revoked. You offered a 504 plan, parent unilaterally revoked. We find in favor of the district for not providing services because they couldn't is the key. Right? They were not allowed. The parent revoked both plans. But do you hear the procedures that were in that? And the continual looking out for the kiddo's needs.
So why did the parent come back to the school?
They were mad.
Want accommodations. So what did they come after the school about not providing accommodations?
I think they wanted a 504 plan that was something different than the IEP. But the school said, you got to hear it. Remember I told you that they're related? There's a Supreme Court case, 1986, where it went before the Supreme saying, remember IDEA came in after 504. And you're hearing various similar themes between the two procedures. There was a Supreme Court case that said, we think IDEA supersedes 504. You don't need 504 anymore because IDEA is in place. That's the way the logic was. Well, Congress didn't like that Supreme Court case, and so they rewrote 504 to say this provision, Section 504, does not eliminate the rights of any other statute. And they wrote that into IDEA as well, saying that you follow IDEA doesn't supersede any of your anti-discrimination rights. So they separated them again. That's why we have this. We have the two, and they tend to go hand in hand. So here's the process. So we've been talking about the process. These are the 5 steps. This is the evaluation under 504. It is a process. You have a 504 referral. You notice the 504 meeting. You seek to consent to attend and evaluate. Remember, the evaluation under 504 is the evaluation is the process. Then you attend the 504 meeting, you make the eligibility determination and design the student accommodation plan, and then you review and reevaluate services at least every 3 years is under 504, but it makes all kinds of sense to do it at least annually, or keeping your thinking caps on, I noticed something different, it seems to be an appropriate time here. To either it's a new activity, a different activity, or something's changing about the child's condition.
And John, can I add that this is certainly best practice, but 504 plans don't actually have to be written down to be in place. So if you're accommodating a student, that could be considered a 504 plan, and if that is later not followed through on, they could still have an OCR complaint. It makes everything super messy, and we always prefer things to be in writing, but the law does not require that it actually be written down to be considered a 504 plan.
That was the logic of the Supreme Court. It's like, well, wait a minute, you have this idea, very detailed process. An IEP must be in writing under IDEA. 504, they don't even say in writing. Must be a plan. That's why I think, personally, well, I got to watch out. OCR, I would disagree with OCR if they told me an IHP is not a 504 plan. It's like, how is it not? It's a plan. And it's appropriately accommodating the child. They would say it didn't go through the process and there's no protections there. With that said, I'm telling you what OCR says. I'm saying still write good IHPs. You want to do appropriate accommodations due to the intricacies of a child's medical condition.
And we would probably also argue that it qualifies as a 504
Okay,
on behalf of the
Good.
parent, so
That's
that they
great.
could enforce those rights.
that's great.
New, because it's not, even when I was in District
Ye-
49, it was like,
Yeah,
Jenny, you remember sitting with me at a table for a charter school here at Lafayette? And it was like, no, if it's a peanut allergy, that should primarily be a healthcare plan. It doesn't require.
yep, it's fairly new. OCR came out with an opinion on that. Right.
At that time, we were mainly just.
It's fairly new. OCR came out with an opinion on that, I want to say in 2016. Something like that. So it's fairly new. So OCR, probably more like 2015. OCR came out with that opinion, and so we can't ignore that opinion. OCR is saying you need to bring, IHPs do not qualify as 504 plans, they need to go through the process.
Last year, it should have been on a 504.
Yep.
So we're going, okay, process.
Right, process. With that said, don't let that get in the way of a good IHP, please.
And
Right?
just remember, 504 it protects students with disabilities. It's not like we have a 504 plan, therefore he's protected against discrimination.
Right.
It's just they're protected under 504 no matter what. So whether it's a health plan or a 504 plan or whatever kind of plan you call it, if they have a disability and they need accommodations in order to access their education, they're just protected under that law.
Let me point out something, and this is what Emily and Jennifer pointed out to me as we were developing these slides. And there is this, you really want to get confused now? Okay? There is the protections still apply to certain students even though you found them not eligible. What? Think about it, okay? I'm going to use Emily as an example. Can I?
Of course.
Okay.
Or I can tell it. You
Okay.
can tell it.
You saw Emily with a prosthesis, right? She's motoring around here quite well, right? And she swims much better than I do, I promise you, right? And as well as that, so the question would be, okay, do you have, let's get to it. You want to draw from information. Here's the process. And a mental or physical impairment that substantially limits a major life activity. That's the eligibility under 504. Does she have a physical impairment that substantially limits her walking? There's walking in there somewhere, walking. See that there? Does she?
I do if
Yeah.
I'm not wearing my leg.
Yeah. Right?
And 504.
Now-
If the accommodation is like, regardless of whether she's wearing her leg or not.
Now, there was a Supreme Court case. This is really getting into the noodles again. All right? There was a Supreme Court case that said, wait a minute. If you're mitigating that, you're not eligible. If you're mitigating that, that's what we want to encourage is mitigation. Yes, we want to encourage self-help skills. We want to encourage other work, right? The Congress didn't like the answer the Supreme Court gave is that you need to take into account mitigating measures. Glasses, right? Congress then changed the law in 2009 to 88, and they said you cannot take into account mitigating factors, right? So we cannot take into account that Emily has a prosthesis. We cannot take that into account when we go through that eligibility. So is she disabled? Yes. Does she need accommodations to access this? We'd have to ask her. But one could say, no. Is she still protected? Yes. Right. That's the other eligibility. That's why those procedural protections are so important. She could complain to us saying, you didn't make this room available to me and I'm in this presentation, and it's on account of I couldn't walk up the stairs or whatever it might be. right? Yes, ma'am.
So would you go ahead and write an active 504 plan?
I never had a 504 plan in school or an IEP. What's that? No. I never needed one.
So the short answer is that this is the OCR saying, no, you don't need a 504 plan, and yes, she can complain about it.
But I could also complain if I was getting harassed because of my prosthetic leg, which is the piece that I think is important. Because I never needed any accommodations for school. I was an honor student and never had any need for any of that. But had students been picking on me because of my disability and I complained to administration and they never did anything, that would also be an OCR complaint.
But they still should have asked you if you needed a 504 because that's the evaluation process.
They probably talked to my mom, like, does she need any accommodations? It really didn't come up for me until college when my dorm supervisor was concerned about me going up the stairs, and so I just ran up the stairs, and that was the end of that conversation.
So in a situation with a child who has a prosthesis or
Yes.
a wheelchair or a hearing aid,
Yes.
we might say, let's hold a meeting.
Yes.
The meeting says, we don't need to make any accommodations, we note that and move on.
Move on and hand them their procedural protections. Yes. And so you're finding eligibility, but think about it in this way, but their needs are being met. So I find this, how much time do I still have?
You have 26 minutes.
Oh, okay. Yeah, slow down. There is I'm in a couple of dog fights with a couple of other attorneys, not these nice people here, right? On what is FAPE? What is free appropriate public education? And the key word I would say, in the free appropriate public education is what? First of all, it's free. Means I can't charge parents with disabilities something I don't charge someone else, right? So we can have certain fees in schools and so on, but I can't say, oh, you're on a prosthesis, you cost $10, everyone else costs $5, right? Oh, because we need a paraeducator, we're going to charge you her salary or whatever, right? It's like, no, can't do that. So it's free, appropriate public education, right? And the key word I'm in this fight on is about appropriate. What is a synonym for appropriate? Sometimes, to get the appropriate definition of something, you look at what synonyms are. What is a synonym for appropriate? Because I would say people misunderstand appropriate. What is a synonym of appropriate? Come on, English teachers. Synonym for appropriate. Proper. Matching. Fitting. Suitable. Right? Those are synonyms, look it up, for appropriate. So it's not a metric like excellent. Excellent has different synonyms. Outstanding or mediocre. People will hear appropriate as mediocre, right? It's like, no, it's not that. It's not a metric of performance. It is a matching exercise. It's fitting. It's appropriate. It makes sense. It is suitable given their condition and given the activity. Do you hear how that is? Like, what makes sense here? Like, no matter what accommodation we gave the child who couldn't swim in a competitive swim match, it was inappropriate. It didn't fit. It wasn't suitable. He would drown, right? And so that's the way you want to be thinking of it, is that it's suitable, it matches, it's fitting, it's appropriate, right? Yes?
Can we go back to the unwritten 504 for a minute?
Okay.
The situation we were talking about where the grandmother was denying a 504, the teacher was still making significant accommodations because the child needed them.
Right.
So can you just,
I would, this is how I sort that out. They might throw something at me back there. If someone, sometimes I hear this, I hear it from special educators too. They'll say, John, do we have to write everything in the IEP? I mean, it's like this is being done, but we write this in the IEP. Shh. It's like, okay, you need to match those. Either what you're doing needs to be written in the IEP, or you need to do what's written in the IEP. then you need to match. It's a matching game, right? Don't do something if it's not over here. And if you're doing something because it's appropriate, then put it over here.
But what if the parent is denying the 504?
Oh, I see what you're saying.
Can you still do it? Like, she's still.
I say this. You want to serve the child, right? And you want to have it make work. I would say you want to make it work for the child, right? And do you want to run a good classroom? I'm not sure what your role is. You want to run a good nurse's office. You want to make sense of what's for the child. If parents come in and, I don't know, close your hand, bind you up in some way, I don't know what they would do. But you want to make things work. This is also true in the world of differentiation, and what's true in general education is that teachers are trained much better than they used to be on differentiating a classroom. You wouldn't even know that there are accommodations. They have various workstations that are appropriately accommodated. If that's what's happening there may not need to be an accommodation in a 504 plan. So I'm not sure of the scenario, but I would not stop you from appropriately serving the child.
And I would say that if that parent were to contact us and say that, I didn't want a 504 plan, but they're doing X, Y, and Z, we would immediately request documents from the school district. And if you have something in writing that says these are the things that we're doing for the student, the legal guardian has denied putting this into a formal 504 plan, but here are all the things we're doing for the student, we would tell the parent there's probably not a lot for them to complain about from our perspective.
And we probably wouldn't get a complaint from a parent like that
Yeah.
because we want to make sure the students' rights are being enforced, not denied, which it sounds like possibly.
So
the
I would
parents
just say
doing that.
document it.
And it was just a denial of.
Sure. And we get parents that call us that don't want their students to be on IEPs but want them to be accommodated. So we certainly understand where you're coming from with trying to manage that kind of, the labeling versus the accommodating. But I would say we will always, us personally as a law firm, will always almost always request documentation depending on the situation. But if it's appropriate to request documentation, we will. And if you have records of that, you're going to be better off from our perspective.
Great. Keep going. There is, if it substantially limits, that line, remember the Supreme Court case I told you about? They said that should be a high standard. Substantial means, and they went to Webster's Dictionary, Black's Law Dictionary, and they defined substantial. Congress changed that. And that they are saying substantially limits is determined without reference to any ameliorative effects of mitigating measures such as this: medicine, use of AT, aids, services, accommodations, so on, like hearing aids and so on. And that it is a low threshold, that substantially limits is a low threshold. It is not to be a barrier, right? It is to, again, and it may be episodic. What are some episodic disorders that may not be apparent all the time? Epilepsy, seizures, broken leg, cancer, right? Other medical conditions that may be in remission or may arthritis, certain arthritic conditions, right? And so those are the things that you're looking for. And we've talked a lot about, can I skip through some of this? Because we've talked a lot about cases and examples. You can see here, here's you be the judge. These are kind of fun, okay?
Are you sending us these to?
Yeah, they will be posted.
Here's a student is struggling academically. Guidance counselor did a pre-evaluation to decide there was not enough evidence to suspect a disability. The mother requested an IEP or a 504 plan. The student continued to struggle. In 2012, the school stated that they had had enough evidence and then completed evaluation in 2012. The mother filed a complaint with OCR. Sorry. What do you be the judge? What do you think? Child find or not child find? Like a violation or not a violation? OCR found that the district failed its child find evaluation. That delay is problematic. okay? Don't overlook the signs of previously homeschooled students. Sometimes, not always, homeschooling is to avoid school. Not always. Don't get me wrong. I know some wonderful people who've, been taught very, very well at home. And sometimes be cautious that it's not because my child has a disability, okay? Student transition from homeschooling to traditional school. Mother reported that he had ADHD. The school believed his struggles were related to transition. The school waited 4 months before initiating evaluation process. The parents filed a complaint claiming that the school did not act quickly enough. What do you think? You be the judge.
4 months seems reasonable. You need some time to get to know the student.
Okay, so let's see what OCR found. OCR found that the South Carolina district should have acted more quickly.
What is more quickly, 3 months? Because you need time to observe. The students come from a homeschool environment, so you need time to.
I think what OCR heard was a medical term. You got ADHD. It wasn't that my child's just struggling and they heard a term. Watch out for anxiety, hints, right? They heard ADHD. ADHD is a diagnosis. So they heard a term and they said, why didn't you act on this to sort out whether or not there was ADHD? Hence why you'd initiate an evaluation. Yes, ma'am.
The school district, they would have pulled together their team, like a problem-solving team, and documented that they had a meeting, say the current, here are the concerns, we're gonna follow up in 4 more weeks.
Right.
It would have been better.
Lawyers love that kind of stuff. We held a meeting, we notified the parents, we hear the procedural protections, then we initiated an evaluation, and we had this data that we brought to the table and considered it. Yes, that's how you'd want to manage that.
And really, once we have the parents' consent to evaluate, we have 60 days to get that
Yes.
evaluation done. So when we're talking about timeliness, just because we're up against a winter break, a spring break, a summer break, doesn't mean that we get to extend out that 60 days. 60 days is 60 days.
And I think 504 just says a reasonable amount of time.
Reasonable amount of time.
But if it's one that you're not sure if it's going to be 504 IEP, you definitely want to err on the side of the 60-day window.
A tip on this slide. We've been talking a lot about this. I want you to look at that last little bulleted point there. Procedural protections are given when you refuse something, as well as when you offer something. So you offer a plan, you provide them procedural protections. You refuse a plan, you offer them their procedural protections. Why? Because their right exists when you offer something or refuse to offer something. And so that procedural protection is there. So that's the watch out for. That's why, could you say no? Sure. Do you want to? Because you would offer them the rights that they have, and they would arguably either complain to OCR for purposes of 504 or file a due process complaint against you in special ed. And you have nothing other than your refusal. Step 2, notice of the Section 504 meeting. Usually that also has their procedural protections with it. Then you agree to attend and evaluate. Again, under Section 504, the meeting itself is the evaluation process, right? You're bringing things to the table. And I cherish general education teachers when they bring their work product, the student's work product, with them to the school or to the meeting. I was in a contentious 504 meeting when I was in Douglas, and the parents had secured a privately funded psychological evaluation for this child who was now a junior. And there weren't, she had recently moved into the district, but she was quite bright, quite capable, and this private psychologist had her like in the 130s or 140s. I mean, very, very bright and very capable. The argument was that she had non-specified dyslexia. Now, those psychologists in the room, what does that mean? Non-specified dyslexia. That means she has dyslexia, we just can't see it anywhere, right? It's like I don't have any data to support it, but we think she has it. So the general education teacher brought her writing samples and her grades to the 504 meeting because there was a question of whether she was eligible or not for accommodations. Just so happened she was up for the ACT. Don't get me going. They're going to throw something at me. Right? And so they were seeking accommodations in school and so on and so forth. The teacher brought in work samples of her and specifically writing samples over the semester she had her and showed progressive quality improvements in her writing and said, I think she just didn't know how to write very well at the beginning of the semester. I'm not criticizing her former teachers or whatever, but in my class, this is her progression, and she's receiving instruction in writing, and look at how well she's writing now. Very powerful data to find that whatever she has, she may be diagnosed as this, but she does not have a disability under 504 according to this team. And that was critical information that the school district had there to say, nope, we're not going to find you eligible. You're doing quite well in school. Her grades were A's and B's. I think they were A's and B's in advanced classes, doing quite well, did not need accommodations. Did I see a hand go up? No, okay. Then step 4, you set up that eligibility determination and you set forth the accommodations. And remember, accommodations, keywords, or synonymous words, suiting, fitting, appropriate, proper, matching, where you're saying, here's the activity and here's the disability, and I'm sorting it out, and it seems like this makes sense. And yes, can a parent complain about that? Yes. And you put together a plan, and under 504, it could be a complaint to OCR. I point back here, they're not from OCR. But they can file from OCR.
We
or
file
they can
with
speak,
OCR.
So they can assist, they can complain about it, but you're listening for proper, appropriate, suitable, and so on, given the child's needs, not an advantage. Most people, by the way, are advantage with extra time. I just need some extra time. Tell that to my daughter when she was taking the MCAT, right? I mean, it's like, in LSATs, give me some extra time, right? I could answer that question if I only had 5 more minutes, right? Nope, pencils down, right? So watch out for understanding the child's disability and the accommodation rather than a given advantage.
And John, the way I like to think about it is that you're really trying to level the playing field.
Right.
You're trying to give the student the same opportunity as all the other students that don't have disabilities. So that's the way that I think about it in my head, is making sure that there is a level playing field for that student that has the disability that impacts their education.
Correct.
So can you talk about the extra time with a kid who has anxiety and is home all the time and has extra time to complete the section?
I think that the answer to extra time issues is understanding their disability and the activity. Like, for example, sometimes I've been requested for extra time on exams and so on because of this and that. My question to the general education teacher is, when does John hand in his assignments? Oh gosh, he's always got him in there with the rest of them. He's just packed in there, right? They all, is there extra time? Is it left? Does it take the whole period, 50 minutes or 60 minutes? No, he'll get his done in about 45. Okay? Is there ever an assignment that's been handed in late because it looks like they just didn't get? No. Do you hear? That's practical, good information for that team to know. And you hear how it's very observational. And it's driven by the teacher who knows them best. Right? So, and it's the nature of their work, the nature of the activity, and the nature of their disability. Like, how does anxiety impact time? Maybe it might. I don't know. But most of the time, anxiety shows up a little differently. Right?
What if it's a kid that's home all the time and missing the instruction and therefore needs extra time?
Yeah. 8 minutes. That's a great question. And do you hear that you have to sort that out? I would sort that out through a process because it's a complex, anxiety is complex. It just really is. And so you have to kind of be sorting that out. Like sometimes it could be they're anxious about something because they don't want to look stupid because they can't read. So the real issue is they can't read. Are you following me in this? So that's what you want to be able to sort out through an evaluation. Because it's not an emotional disability, it's a reading disability.
Which is why it would be a special ed evaluation.
Bingo. Okay, so let me keep going.
I was just noticing a
I was
question.
just gonna ask, what's an appropriate accommodation for a student who doesn't go to school?
You better work hard to get that student to school. Because we got $15,000 from a district because they weren't doing enough to get a student on an IEP back to school. So the school district definitely has they need to make an effort.
I,
They don't come to school?
I will tell you what I tell my principals when they call is that a truancy and an attendance issue is totally separate than the disability. So continue to attend to the disability and whatever that child needs to be in school. John has done 2-hour trainings with BOCES on this very issue. So we could spend another 2 hours on separating out the issues. But I would say don't allow the parent to keep the kid out of school. Doing nothing is the worst thing that we can do. And, you know, I hear from principals all the time, well, the parent's been really nice about it. The parents brought doctor's notes. Well, the next call would be to that healthcare provider to say, did you intend for the kid not to attend school? And 9 times out of 10, the doctor will say, no, that was never my intent. The kid should be back in school. The kid needs to go to school. Okay. And so, again, we need to bracket that part, but I do want to emphasize, do not do nothing and allow the parent to keep the kid out of school.
Yeah, the short version that I say on that is evaluation sorts all that out. You sort that out because it's complex. Because you get into relationship issues, you get into learning issues, you get into bad habits, you get into drug issues, you get into other things that are family issues. Can be very complex. And the best way to sort that out is through evaluation.
Continue to pursue attendance
Yeah,
from an attendance standpoint.
from an attendance standpoint. And
how does
over
the
here,
group
looking at the
feasibility
accommodations.
simultaneously?
Yep. Yep.
And if they continue not to show up at school, then we pursue the truancy side
Yep.
while we still continue to offer.
I was in truancy court when I don't do that now, but I've served in truancy court in the past, and I had a child with a profound disability and her parents in truancy court. And the judge was letting them have it. You need to get your child to school. And they did all this stuff, the crying, and it's like, get your child to school.
I said, hire an attendance Nazi like we have. Literally an attendance Nazi, and she's yelled at me before for being too nice about something.
Yep.
Yeah, and principals are the, what am I trying to say? The keeper of that record, the custodian of that record. And so, it comes down to why didn't the principal follow the truancy procedures we have in place?
I'm going to say that this note here is, I've seen this happen. It's very appropriate to be collaborative and to have people be co-responsible and so on. 504 plans are your responsibility. They're the district's responsibility. They're not the parent's responsibility or the child's responsibility. It's very clumsy to try and argue that a child with an impairment has to argue for themselves. Now, you could be teaching them self-advocacy skills, or you can teach them coping skills. You can teach them skills. That's much different. That's more a special ed world. And you show progress on those and so on and so forth, right? But to burden a child with the accommodations that you are to provide is backwards, right? So you want to watch out for that. And for the most part, parents and children are very cooperative and very collaborative, and so you want to capture that, but don't put it in the plan. The plan is for you and us to appropriately accommodate the child. I'm going to go through this case. Step 5, review the services, periodic reviews. Under 504, it makes sense to do them at least annually. And at least every 3 years you can reevaluate. You are to reevaluate. And here is a case on health conditions. I don't know what I had there. Oh, and this is the Kimball case I told you about. Here. And this was out of the district court, 2013. And tips to consider, start with a robust evaluation. If you've been hearing me say anything, it is you want to know information about this kiddo. And consider under Section 504 whether you need to lean on your special ed colleagues. And consider OHI, other health impairments for children with chronic needs, medical needs. Here are the red flags. Parent or teacher frequently expresses concern. You got to hear this as a concern. It's a request. I know sometimes they come across very harsh maybe, but you just need to hear it. Retention, non-attendance, the student is not benefiting from instruction, serious illness or injury. When a child is referred for assessment but is determined not eligibility under IDEA, note, keep the procedures distinct, right? You want to kind of set that up. Some of the most valuable information you'll get is from your special education team. You can certainly consider that in a 504, but just keep the procedures distinct. That's what Kimball did. And again, it must be made by knowledgeable students. That's that group of people knowledgeable. And, manifestation determinations. Manifestation determinations are not specifically mentioned in IDEA, mentioned in 504. They are mentioned in IDEA. So 504 borrows from IDEA because it's discriminatory. Think of it that way. For me to expel a student for misconduct that is on account of their disability. Okay, so we have to hold manifestation meetings. The exception under 504 is for drugs and alcohol.
Is the time frame similar to that you expect?
Yes, 10 days. The 10-day rule, either 10 consecutive or 10 days that form a pattern. Right, significant change of placement. And so here are the remembers, and here are the do's and the don'ts.
And did you want to just mention about homeschool enrichment program?
Yes. All this applies to the homeschool enrichment program.
Just to make sure it's clear.
Just to make sure it's clear. Because what is the homeschool enrichment program? It is a school program. Now, it's homeschool, right? But it's the school district's program. So the accommodations would be so a student can access that program. Are you following me? It's different than an IEP. Homeschoolers are not, homeschooling is not, you're not eligible for special education as a homeschooler, right? And if you're in a homeschool program sponsored by the district, you need to be appropriately accommodated, right? So it's different.
One other thing that they are qualified for, even if they are exclusively homeschooled, if they come to you wanting child find services or you through child find process suggest an evaluation, as a district we have an obligation to do that. So make sure you're letting our child find team know if you're encountering those situations.
If they live in district.
In district, correct. Okay. Yeah. Otherwise we would refer them to their district of residence.
Notice that one of the do's is just to consider a special education evaluation. The don'ts, substitute a 504 plan for an IDEA eligible student, or don't conduct an MDR for drugs or alcohol. That's just a carve out that was written into 504. Whew.
That's a lot.
You did good.
Yeah.
How much time?
We're over 2 minutes, so.
So
But-
over by 2 minutes, so we can't even do this.
Well,
Questions, comments?
I'll defer to the three of you.
We've
whether or
addressed
not
each of
you-
these questions, yes? Very thoroughly.
I think we just wanted to mention the policies.
you know, if you have permission to run out of the room, but are there any last minute questions that you'd like our panel of?
I know what, like, we had our nurse and our IEP, one of our special, our resource teacher was able to be here. And we were just kind of like, oh, we are gonna have to go over some of this with them. And so I think the biggest question is gonna be with the special ed department, on the child line, making sure that there's enough time, because we know staffing and we've had those conversations about, she's gonna say, well, how in the world can I do all this? And the school site is gonna say, how in the world can I do all this testing if we go through the procedure and there does need to be that?
Yeah.
People are tapped out.
Yep.
And so I think that's just.
It's in your contract, though, to have that support specifically for the evaluation process. So just know that the district is here to support the evaluation
And
process.
by contract, you mean the charter?
The charter contract with both
agreement.
charters, yeah.
I will tell her that it's okay. We're gonna get lots of.
We're gonna work as a team. That's what we are. So.
Great.
I do want to make mention, under our district policy, AC, we have our non-discrimination policy. Sorry, thank you, I was reminded. I was just getting up to mention that our district has non-discrimination policy under AC, and it specifically provides protections under 504. That's one of the carve-outs. Recently, TCA had updated their policy as well. So I don't want to call you out, Sherry, but can I call on you to share those updates? And it is posted to the website. By the way, the district has a new website, and I'm really proud to say that when we updated our website, we updated and was hyper sensitive to accessibility issues with our district website, as well as procedural compliance and safe and parent rights and district responsibilities. So all of that is uploaded to our new website. And so when that goes live, it is live now, but it has not replaced the old website. So you'll still find what you're used to on the old website, but when that new website goes live, it will eventually take down that old website, and I think we're going to be doing a much better job at meeting the mark with communicating procedural safeguards to our community, as well as policy and where to find their rights for raising any concerns.
TCA's non-discrimination policy was updated last year. A paragraph was added to the first page regarding 504s, and I encourage anyone in admin to read this occasionally. The other change was the non-discrimination contact for HR. We have a new staff person, Alicia Raymond. Alicia is the contact for staff complaints, and I continue to be the contact for student complaints. So just know it was wording and clarification regarding 504 and 88 policies, and that they apply to all of our programs, including Cottage School.
Else you wanted us to expand on there? Okay. Well, I really appreciate the time of the team here to provide you with this tremendous amount of information. And they do much more justice to the topic than I could do on my own. I really appreciate Emily and speaking from her personal experience, Jennifer here with her level of knowledge and expertise, both of them from the advocacy point of parents and students. I appreciate John. John brings us a wealth of knowledge on this issue, and I'm always here as a support. So don't ever hesitate calling and asking questions. If you are not a school administrator, I'll first ask, have you talked to your school principal? Because a lot of times our principals have the answer, or they want to have the first opportunity to problem solve through that with you. And then principals call all the time for my help and support, and that's what I'm here for. That's part of my job. Any questions before we wrap up? Any questions that are pressing that you don't believe were answered through the presentation? All right. Well, thank you again, and thank you so much to our guests.